Hi Kate, the last time we spoke we were talking about ASIC's report on handling confidential information, and that was in response to the Newcrest allegations of selectively briefing analysts. And last week we got the sequel to that, because Newcrest has actually agreed to the facts. It's agreed that it was in breach of its continuous disclosure obligations under ASIC listing rules, and it actually agreed to cop a $1.2 million fine, which was a record.
Big numbers there, Gavin. What should other listed companies learn from this?
Well, listed public companies will need to closely consider ASIC's recommendations in relation to handling confidential information. As far as selective briefings are concerned, Newcrest have adopted some protocols which ASIC are happy with, and they include things such as webcasting analyst briefings, putting up materials on the company's website and releasing them to ASX, and having blackouts before the company makes regular announcements of results and the like. So companies will need to consider those protocols and adapt them to their own use.
Gavin, what about the analysts in this case? Could we see ASIC take any action there?
Yes, well, rather ominously, ASIC indicated that they were still investigating the analysts, so it's quite possible that we might see some insider trading proceedings come out of that. You might argue that that's a bit unfair on the analysts, because it's over to the companies to make sure that they don't disclose price-sensitive information. But of course, under the law, if you ought to know that information is price-sensitive and confidential, then that's the same as if you actually knew. So ASIC's argument would be that if you are an analyst, you follow a company, then you should know what information is publicly available and therefore be able to recognise information when it is price sensitive and confidential. So that will be the argument if there are any such proceedings. By the way, the settlement between ASIC and Newcrest related only to its continuous disclosure obligations, so it's quite possible that if proceedings were brought against analysts, then Newcrest executives could be in the firing line as well.
So we're still a case to watch then?
I think so, yes.
Gavin, thanks so much for joining us.
Pleasure.